Hello, everybody. Welcome back to Office Hours Politics Edition. I'm your host, the one and only Ziana Aly. If you can't tell, I'm kind of group filming these here. I'm on a roll. Did you guys see my new thumbnails? I just made a few. I think that they're so fun and fresh. Let me know how you feel about them. I truly feel like Picasso on Canva. Anyways, today we are unpacking a myth that sits at the heart of our very democracy, if you will. It's the myth of neutrality in law. We often hear that law is impartial, that judges merely apply the law, that courts exist above politics, and the Constitution speaks for everyone equally. But the truth is far more complex and far less comfortable. Today, we're diving deep into how neutrality operates as a myth, a story we tell ourselves to sustain faith in legal institutions. In practice, they reflect biases, histories, and hierarchies of society that they emerged from. We will zoom in on the Canadian legal system, looking at how constitutional law, judicial activism, and institutional bias challenge this idea of neutrality. Because when we say law is neutral, we ignore who wrote it and who interprets it and who benefits from it. So let's get into it. Let's start with the core question. Can law ever truly be neutral? In theory, yes. Neutrality implies that law stands apart from politics, that judges decide cases based on objective reasoning, not personal bias or ideology. But in practice, law is created by people, and people bring history, prejudice, and perspective into everything they touch. In Canada, the supposed neutrality of the legal system has often masked deep inequalities. Our Constitution, often celebrated as the pinnacle of fairness, was born in a colonial context. The very foundation of Canadian law rests on British legal traditions, the doctrine of discovery, and centuries of Indigenous dispossession. So when we talk about neutrality, we have to ask, neutral for whom? Consider the Indian Act, or the way Indigenous legal orders were dismissed as customs rather than law. Neutrality here wasn't neutral at all. It was a tool to impose one legal system over another. Neutrality functions as a shield, a way for institutions to claim legitimacy while maintaining power. The idea that judges are just interpreting the law allows them to make deeply political decisions without accountability. Think about landmark Supreme Court decisions. They're not simply legal exercises. They're moral, political, and cultural statements about who we are and what kind of country we want to be. Turning towards constitutional law and power. Canada's constitution, especially the Charter of Rights and Freedoms, is often treated as sacred. It is the ultimate arbitrator of justice, equality, and freedom, but it also reveals how law never truly detaches from politics. The Charter gave courts immense power to define what our rights mean. And that means unelected judges often make decisions that shape the very fabric of Canadian society. Think about the abortion case of 1988, which struck down Canada's abortion law, or Carter v. Canada in 2015, which legalized medicated assisted dying. These were monumental shifts in social policy, not made by Parliament, but by the Supreme Court. Supporters call this judicial courage. Critics call it judicial activism. In the example of the abortion case, the courts left room for Parliament to respond, and it failed to do so. That's my perspective. But again, critics would call it judicial activism. Either way, those decisions weren't neutral. They reflected value judgments about autonomy, dignity, life, and morality. And those judgments, while grounded in legal reasoning, are shaped by worldviews of the people making. Even the notwithstanding clause in Section 33 of the Charter exposes this tension. It was supposed to balance judicial and legislative power, but it also highlights how neutral law depends on who holds political authority and how far they're willing to go to override rights. Neutrality in constitutional law is really about which values are normalized as universal and which are dismissed as political. Or moving towards my comment on judicial activism and exploring that a little bit further. Judicial activism is a phrase that gets thrown around a lot in Canada, like I said, as a criticism. When judges strike down laws or interpret the Constitution in progressive ways, they're accused of making law rather than interpreting it. But when they make conservative rulings that preserve the status quo, they're often described as judicial restraint. So neutrality becomes conditional, acceptable when it aligns with certain political values, but activist when it doesn't. Let's look at the Supreme Court of Canada. Its decisions over the decades reflect shifts in political climates, like from the post-war liberal consensus to the charter era of rights and consciousness. For example, R.V. Sparrow in 1990, the court recognized Indigenous fishing rights, but still placed them within a framework defined by the Crown. That decision was hailed as progressive, but it also reinforced the colonial structure by requiring Indigenous rights to be proven within settler legal systems. Even in gender equality cases, like Andrews v. Law Society of British Columbia in 1989, where the court established the foundation for equal rights, the reasoning still reflected a narrow, Eurocentric understanding of what discrimination looks like. Let's not forget, Canada's judiciary has a history of lacking diversity. The bench has been overwhelmingly white, male, and upper class. Big shock. Judges bring their life experiences, their education, social networks, and unconscious biases into the courtroom. So when we talk about judicial neutrality, we're really talking about whose neutrality, because neutrality often means aligned with dominant world view. But last time I checked, white rich male, I don't know, guys, something's a little fishy here. Moving on to institutional biases, because people definitely play a big part in this inequality, but I would argue the bigger issues are within the systems. Let's think about access to justice. Who can afford to bring a constitutional challenge to the Supreme Court? Who has time? Who has money? Who has the resources to fight a case that could take years? Neutrality assumes a level playing field, but the playing field has never been level. Racialized Canadians, Indigenous people, women, and marginalized communities often encounter systemic barriers, from over-policing and sentencing disparities to underrepresentation in legal education and professional spaces. Consider GLADU principles, meant to reduce over-incarceration of Indigenous offenders. Despite good intentions, Indigenous people still make up over 30% of Canada's prison population, while being less than 5% of the nation's population. I'm not a mathematician, not very good at math actually, but does not seem like neutrality to me. That's a system reproducing inequality under the guise of fairness, which is the most ridiculous part. Even in the courtroom, the language of neutrality can obscure harm. Words like objective and reasonableness often reflect white, Western, male norms of rationality. What counts as a reasonable person in the law is not a universal standard. It's a cultural construct. And this extends to legal education. Law schools teach students to think like lawyers, which often means stripping away emotion and context. But in doing so, they reproduce the idea that emotion, identity, or lived experience has no place in law. That's how bias becomes institutionalized. Not through individual prejudice, but through systemic design. Let's go deeper, because even interpretation itself is political. When a judge interprets a statute or constitutional clause, they make choices. They choose which precedents to emphasize, which principles to prioritize, and how broadly or narrow to read a right. Take Section 7 of the Charter. Everyone has the right to life, liberty, and security of the person. Those words are universal, but their meaning isn't. Over time, courts have used Section 7 to strike down abortion laws, assisted dying bans, and immigration detention practices. Each case redefines what security of the person means, showing that neutrality doesn't even exist in textual interpretation. Even the idea of original intent, the judges should stick to what the framers meant, is political. This assumes that the framers' worldview should permanently guide a multicultural, evolving society. Huh? On the other hand, the Living Tree constitutionalism, the Living Tree doctrine, whatever, Canada's doctrine that the Constitution grows and adapts, is also, again, political. It reflects liberal progressive ideals of inclusion and evolution. So when someone says a decision was activist or neutral, what they're really saying is, I disagree with the politics behind the decision. Interpretation is never neutral. It's always a conversation between the text, the interpreter, and the world they inhabit. So where do we go from here? If neutrality is a myth, do we abandon the idea of impartial law altogether? Or do we reimagine what impartiality could mean in diverse democracy? A more honest legal culture begins with acknowledgement, acknowledging that bias exists. It doesn't weaken the system, it strengthens it by making it self-aware. This means more diversity on the bench, more Indigenous legal traditions taught in law schools, and more recognition that emotion, empathy, and identity matter in law. It also means rejecting the false comfort of an apolitical law, because law is political, but it doesn't have to be partisan. It can strive for fairness, transparency, and accountability while recognizing that justice is not a fixed point. It's a constant negotiation. Imagine a legal system where neutrality doesn't mean erasing difference, but balancing it, where impartiality isn't the absence of identity, but the inclusion of many. That's not idealism, it's evolution. So, what's the takeaway? The myth of neutrality allows those in power to hide behind objectivity while shaping society in their image. Once you see the myth, you can't unsee it. Law is not neutral, it's a mirror. What it reflects depends on who's holding it. Recognizing this doesn't make us cynical, it makes us reasonable, because justice requires consciousness, courage, and the willingness to see where fairness has failed. Canada's legal system isn't broken, but it's not perfect either. Its strength lies in its ability to evolve, to confront its own contradictions, and to move towards something more inclusive, more honest, and more human. So the next time someone tells you that the law is neutral, remember neutrality is never neutral. It's a choice. I'm Ziana Aly. This has been Office Hours Politics Edition. Until next time, stay curious, stay critical, and never stop questioning who justice really serves. Bye, guys.